This appeal is set for judgment today. And I read. How you can hear me well, Council? Yeah, Mr. Can you?
No, Mr. Chairman, I can't hear you very clearly.
Can you hear well? Can you hear us well?
Yes, Mr. Chairman, I can hear you now.
Okay, all right. I'll try to speak as loud as I could. Okay. Background. The applicant applies for appeals against the respondent to client discuss assessment of 667,772,500 naira for the years 2015 to 2020, which was subject of appeal number TAT/IB/072/2023, filed on 7 July 2023, and 54,862,948 naira and 54 kobo for the years 2019 and 2020, which is the subject matter of this appeal number TAT/IB/073/2023. The motion consolidating the two appeals was moved by the appellant and granted on the 25th day of April 2024 with a view to hearing the two appeals together. The appellant's reason for consolidating the two appeals was because it's rightly thought that the respondent intended to pursue the two alleged assessments against it, as the respondent did not anywhere in his letter of demand for the second BOJ assessment for 54,862,954 for the 2019-20 years of assessment, mentioned that it was no longer pursuing its first assessment, or that it had been superseded by the second BOJ assessment. This was the state of things until 28th April 2025, when the respondent's counsel from the bar informed this honorable tribunal that his client had withdrawn and abandoned the 607,772,500 BOJ assessment and replaced it with the 54,802,948 BOJ assessment. According to him, this was an acknowledgement for the fact that the 607,772,500 naira BOJ assessment extended beyond the years that the appellant of this agency banking business in the state, while the 54,862,948 BOJ assessment related to the actual years, such being from 2019 to 2020 years of assessment. On this basis, and to the extent that the said 667,772,500 naira BOJ assessment was based on appeal number TAT/IB/072/2023. This honorable tribunal struck out appeal number TAT/IB/072/2023 at the sitting on 20th April 2025. Accordingly, this leaves the present appeal where the appellant is contesting the respondent's 54,862,954 for BOJ assessment for the alleged utility tax due on the commissions paid to the appellant's point of sale agents in the state for the period 2019 to 2020 as the appellant's surviving appeal on which both parties have turned issues for determination before us. Facts of the case. The appellant's notice of appeal dated 12 December 2023 was supported by the witness statement on oath of Rex Wadoka, dated and filed on 13 December 2023. This was subsequently withdrawn and replaced by a witness statement on oath of Ifogale Dodume, dated and filed on 17th May 2024. This was further withdrawn and struck out by the honorable tribunal on 5th May 2025 and replaced with the 15th paragraph witness statement on oath, dated and filed on 5th May 2025, supported by appropriately marked exhibits. Pursuant to this Honorable Tribunal's order, granted on 16 July 2025, the appellant filed the second witness statement on oath, dated 16 July 2025, which its witness adopted on 13th October 2025. Through this, the appellant sought to tender its consultant's emails to the respondent, dated 23rd February 2022, 4th March 2022, and a letter dated 4th December 2023, which were admitted in evidence among as exhibits UPA 11, UPA 12, and UPA 13, respectively. The witness advised that the respondent carried out the tax investigation on the appellant for the years 2019 and 2020. At the end of the exercise, the respondent issued a demand notice dated 24th October 2023 for additional 54,862,914 assessment made up of 42,529,417 naira for 7 kobo, with only tax liability 4,252,941 naira 75 kobo, being 10% penalty, and 8,080,599 naira 52 kobo interest thereof at 21% per annum, admitted in evidence and marked as Exhibit UBA1. The appellant objected to the said BOG assessment through its tax consultants, questioning the applicant via its letter dated 12 September 2023, admitted and marked as Exhibit UBA2. In response thereto, the respondent issued a notice of refusal to amend the assessment. NORA reference number IRS/TAS/1464/089, dated 7 November 2023, admitted and marked as exhibit UBA3, order to which the appellant instructed his lawyers to file this appeal against the respondent. The appellant's position has availed two witness statements of oath and the oral evidence of its witness before the tribunal on 20th April 2025, 29th May 2025, 25th June 2025, and 29th October 2025 is to the effect that A, is made available to the respondent all the information and documents requested in its tax investigation to determine the appellant's compliance with its withholding tax obligations for the years 2019 and 2020 via its emails of 24th July 2023 and 24th July 2023, reference to the tax consultant's consultation letter dated 12 September 2023, which was admitted and marked as Exhibit UBA2, and the tax consultant's letter dated 4th May 2022, admitted and marked as Exhibit UBA4A, and 12th June 2023, admitted and marked as Exhibit UBA4B. Exhibit UBA4B, reference Exhibit UBA4A, by which the applicants supplied the requested information and documents to the respondent via the email addresses listed in the said exhibit UBA4B. B, the respondent did not evaluate its submissions on its merits before issuing the above reference to the assessment, which had no correlation to the records of its transactions in the state in 2019 and 2020, and was accordingly excessive. The respondent C, the respondent overstated the commission's attributed to the POS agents for the period of the state. So the extent that the respondent failed to identify the POS agents to whom the commissions on which the additional withholding tax was assessed were paid. D, it provided the respondent the breakdown of its non-detailed position, list of addresses, transaction numbers of its POS agents residents in Ondo State, spending of transaction types indicating fees and commissions due to POS agents in the state, which were tendered in evidence and marked as Exhibit UBA6. E, it had fulfilled its withholding tax obligations by remitting the relevant and applicable withholding tax to the respondent through its remittance receipts for December 2019, August 2020, September 2020, and November 2020, admitted as Exhibit UBA7, UBA8, UBA9, and UBA10, respectively. Council, you need to be on camera. If you're not here, you need to be on camera throughout the time that this judgment is being read. I hope you can hear me. Counsel to the appellant, if you're not here, you need to be on camera throughout these proceedings.
We can hear you now. I'm sorry. We couldn't hear you for a bit, for some time. But we can hear you now.
We have to see your
Can you
face.
hear us?
I can hear you, but we have to see your face. Yes. Virtual hearing and virtual proceedings are meant to be as if you are here physically. So you can't turn off the camera. If the representative or counsel for the respondent will do say that if you are here, please turn on your camera. And you need to announce your presence. Who is Mapa Peter Oluwa to sing? Can you please disclose your identity? Mapa Peter Oluwa to sing. Or make yourself if you are talking. Mapa Peter Oluwa to sing. Can you unmute yourself and disclose your identity to us? Okay. Register, please exit the person. Because the person is not here, just exit. Exactly, thank you. To counter the appellant, the respondent filed a 31 paragraph counter affidavit and witness statement of oath, sworn to by Ademonte Mustaki, an assistant director and head of tax audit, the employee of the respondent, dated and filed on 29th 2025, and the 7-paragraph counter claim against the appellant due to summarized below. Paragraph A. That the appellant commenced US agency banking in 2019 and prior to obtaining the Central Bank of Nigeria's approval, and that 2014 was the year of its official commencement of mobile and agency banking operations for Nigeria, including Ondo State. However, the respondent's witness did not tender any document to substantiate his assertion. Paragraph B. That by its letter dated 14 July 2021, it requires the appellant to produce certain documents listed in paragraph 15(1) to 4 of the standard affidavit to establish its total tax compliance, which the appellant did not provide. Rather, in response to its letter reference to by PFO /GT /ODRS /0608 /2021 of 8 2021. The appellant by its letter of 6 August 2021 only provided a document named Main Contract Schedule, quote, Main Contract Schedule, unquote, sample withholding tax remittance for May 2021. Paragraph C. That it initially issued a demand notice, reference number IRS/TAS/1464/019, dated 15 December 2021 for 772,500 naira, paid accessory for withholding tax on commissions paid to its POS agents in the state from 2015, which it later withdrew and replaced with a revised demand notice, reference IRS/TAS/1464/066, dated on the 4th of August 2023 for 54,867,948 naira 54. Based on the review of some of the documents provided by the appellant, of which it complete. Paragraph D. That the appellant supplied information related to only 120 POS agents commission accounts out of the total of 2,207 POS agents transactions made available, leaving a balance of 2,127 POS agents transactions. Paragraph E. That while the applicant's emails some documents, including the financial statement for 2020, it did not provide the actual individual trading and commission accounts of the agents which is needed to start the applicant's withholding tax obligations. Paragraph F. That the applicant did not honor its formal request for production of individual trading and commission accounts of each of its POS agents in the states. That's why the respondents request for it to do so by letter of 11th April 2020. Paragraph G. That by letter reference IRS/TS/1464/089, dated 7 November 2022, rejected the appellant's objection to its assessment on the basis of insufficient information, incomplete documents, including non-availability of the commission account statements of the remaining 2,147 agents for 2019 to 2020, and refused to amend the assessment accordingly. Paragraph H. That this honorable tribunal lacked jurisdiction to entertain this appeal, as the appellant did not serve it a quick action notice. Paragraph I. That in addition to ordering the appellant to pay the public interest 2,914 for guilty assessment, the honorable tribunal should grant his character claim and order the appellant to pay his 30,756,051 naira 20 kobo interest issues for retaliation. The issues as formulated by the council to both parties in their respective final written addresses are as follows. A. The respondent. Paragraph 1. Whether the honorable tribunal has the jurisdiction to entertain this appeal on grounds that the subject matter of the appeal is totally as collectible by the respondent on behalf of the Ondo State government on the one hand, and the appeal is immature and not right for filing on the other hand. 2. Whether the appellant who has the most of proof and discharged the onus of proving that the revised withholding tax assessment of the public 862,000 for 2019 to 2020 is excessive. Appellant. 1. Whether the respondent's guilty assessment is arbitrary, unjustifiable, and inconsistent with the inclusion of applicable laws and not to be set aside. 2. Whether the appellant is liable for penalty and interest having objected to the tax assessment within the time limited by law. For the purpose of determination, we have compressed the 4 issues faced by the parties into 3 and resolved them in the following order. Number 1, whether this honorable tribunal has the decision to entertain this appeal on the grounds that 1. The subject matter of the appeal is withholding tax collectible by the respondent on behalf of the State government on the one hand, and B. The appeal is immature and not right for filing on the other hand. The second issue for determination, whether the appellant has discharged the onus of proof that the respondent's BOG assessment is excessive, arbitrary, unjustifiable, and inconsistent with the provisions of applicable laws and not to be set aside. Third issue for determination, whether the appellant is liable for penalty and interest having objected to the assessment within the time limited by law. Before we go into the parties' arguments, it is necessary for us to isolate the first leg of the jurisdictional issue raised by the respondent referenced as item 1A above, that is, that quote, the subject matter of the appeal is totally tax collectible by the respondent on behalf of the State government on the one hand, on quote, and dispose it of preliminarily without going to the merits. This is a view of the ruling of this honorable tribunal on the 31st day of February 2024, where the respondent's preliminary objection to the jurisdiction of this honorable tribunal on the same ground was dismissed. The respondent had the opportunity to appeal the ruling if it was satisfied with it, but chose not to do so. For the respondent to resuscitate the same ground for challenging the jurisdiction of this Honorable Tribunal, after hearing the substantive appeal, is to say the least frivolous, vexatious, and unabused of the tribunal process. Accordingly, our resolution of the judicial issue on the merits will be limited to the second leg, reference as item 1B above. That is, quote, the appeal is immature and not right for filing on the other hand, unquote. Parties' arguments. Below is a brief summary of the arguments of the parties on the issues. Number one, jurisdictional issue. The respondents' counsel argued that the appeal is premature and not yet due for filing at the time it was filed. The anchor is argument on what he elicited from the appellant's witness during cross-examination to the fact that the appeal was filed when the parties were still exchanging correspondence, which exercise continued even after the filing of the appeal. He further referred us to paragraph 5 of Exhibit 313, dated 1st December 2023, which confirms that the appeal was filed while the parties were still exchanging correspondence. The respondent did not cite any statute or case law to support the submission. To counter the respondent, the appellant chronicles the sequence of events as follows. A. By letter dated 24th August 2023, for served on the appellant on 8 September 2023, the respondent issued the second demand notice sum of 4 million naira, 862,948 naira for the years 2019 and 2020. B. Dissatisfied with the demand notice, the appellant through his tax consultant, President Pedalo, objected to it by letter dated 12 September 2023, which was within 30 days of the date of the assessment. C. The respondent issued a NORA dated 7th November 2023. D. Dissatisfied with the respondent's NORA, the appellant instituted this appeal on 12 December 2023, which was within 30 days of the date of the NORA. On this basis, the appellant urged us to dismiss the respondent's criminal objection to the Honorable Tribunal's petition. Issue number 2. Whether the appellant that is charging orders of proof that the respondent's guilty assessment is successfully arbitrary, on the justifiably consistent and inconsistent with the provisions of our legal laws are not to be set aside. It is noteworthy that the respondent's counsel did not specifically address this issue in its final written address. Thus, the only thing that we can glean from this final written address is that the appellant did not provide documents at all, but that the documents he provided were incomplete and insufficient, according to the position and oral evidence of the respondent's witness and his counsel's final written address. The appellant only provided the schedule of the utility tax collection in respect of 150 out of its 2,267 registered POS agents. However, the actual number by the QPA5 is 2,248. Leaving out the schedule of utility tax collection in respect of the remaining 2,147 POS agents, which actually should be 2,128. The appellant, on the other hand, provided the following copious evidence and presented arguments relating thereto to prove his case against the respondent, and urged this Honorable Tribunal to set aside the entire POG assessment. 1. That the appellant had filed his utility tax returns for the period and remitted the tax deed and payable to the respondent, and further provided all the information required by the respondent to audit and determine the extent of his compliance with utility tax obligations before the respondent issued his POG assessment of 4,862,914.54. 2. The appellant provided the documents requested by the respondent via A. His tax consultant's letters of 4th May 2022 admitted and matters 64A, 12 June 2023 admitted and matters 64B, Exhibit UPA 4A, 12 June 2023 admitted and matters Exhibit UPA 4B, and 3rd July 2023 admitted and matters Exhibit UPA 4C. B, the image of 23rd to 23rd February 2022. Man has exhibit UB 11 and 4th March 2022. Man has exhibit UB 12. And C, the staff consultant's letter of 4 December 2023. Man has exhibit UB 13. 3. The applicant provided the following documents requested by the respondent by exhibits UBA 4A, UBA 11, and UBA 12 referenced above to the respondent before the respondent issued exhibit UBA 1. 1. Breakdown of undisputed positions of the bank. List of addresses and transaction numbers of agents with residents from those states. 5. 3. Onboarding forms signed by the agents residents from those states. 4. Schedule of transaction types indicating transaction fee and commission due to agents. 5. Audited financial statements for the year 2020. 6. Name and address of mobile money agents residents in those states. 7. Commission account for mobile money agents residents in those states. 8. Schedule of utility tax remittance and evidence of payment. Exhibit UPA 6 to 10. 9. For those states schedule of mobile money transactions according to transaction types for year 2020. 10. Agreement with mobile money agents. Paragraph 4. By a letter dated 5th May 2022, admitted and mad as UPA 4A, the appellant provided the following document to the respondent. 1. Breakdown of the student position on the bank. 2. List of address and transaction numbers of agents resident in those states. 3. Onboarding forms signed by the agents resident in those states. 4. Schedule of transaction types indicating transaction fee and commission due to agents. Paragraph 5. By the UPA 4B, a letter dated 2023, the appellant further provided the following documents to the respondent. 1. CBS approval to commence agency banking operations. 2. List of agent addresses and transaction numbers. 3. On those agent onboarding forms. 4. Schedule of transaction fees. Paragraph 6. By email dated 23rd February 2021, exhibit UPA 11, the appellant provided the following documents to the respondent. 1. Audited financial statements for the year 2020. Name and address of mobile money agents residents in those states. 3. Commission accounts of mobile money agents residents in those states. 4. Trading accounts of mobile money agents residents in those states. 5. Schedule of utility tax remittance and evidence of payment. Paragraph 7. By email dated 1st March 2022, man is with UPA 12, the appellant provided the following documents to the respondent. 1. For those schedule of mobile money transactions according to transaction types for the year 2020. 2. Agreement with mobile money agents. Paragraph 8. The revised assessment was not derived from the above reference information or documents provided by the appellant in the first. 9. Paragraph 9. Having failed to provide the basis for the revised the assessment or show where it got the figures from, the respondent has clearly failed to meet the conditions for issuing the valid grade. Paragraph 10. The respondent failed to identify the agents to whom the BOG assessment relates or any other accurate information to support the BOG. Paragraph 11. The BOG assessment is excessive as it did not reflect the records and transactions of the financial operations of the year 2019 to 2020 and being bereft on the basis of examination. It is arbitrary as it failed to get the pillars of a BOG assessment. This is number 3. Categories continue. Whether the appellant is liable to penalty and interest, having updated to the tax assessment in the time limited by law. The respondent did not address this issue in his final address. In light of this, there is no evidence or argument before us against which we can weigh the following evidence and arguments advanced by the appellant. Paragraph 8, the appellant objected to the assessment within the time prescribed by law, and that accordingly, as decided in Amadu versus Governor of the State, 2009, 1,000 report of Nigeria, 319, there is no legal basis for subjecting the appellant to pay a penalty and interest in statute. Paragraph B, as decided in Weather for Services, SDRL, versus FRS 2016, 2026, taxpayer report of Nigeria 2024, where taxpayer objects to an assessment within the time provided by applicable law. Taxpayer cannot impose the penalty and interest on such an assessment. Paragraph C, as the appellant objected to the respondent's demand notice and moral by exhibits PPA 2 and PPA 13, and findings appear within the time prescribed in the applicable law. The BOD assessment is not final and conclusive, and the respondent cannot impose penalties and interest thereof. Findings of fact. Below our major findings of fact. One, the appellant was licensed by the CPF in November 2019, as confirmed by CPF data of no objection reference PSL/PLD/COL/CW0/01/110 dated 4th November 2019. Admitted and not assessed the QB4, which the respondent did not controvert with any credible evidence to contrary. 2. This appellant submitted the information and documents requested by the respondent during the task investigation of the appellant's records, which the respondent, through his witness, denied receiving in one day and acknowledged receiving them in another day, but that they were incomplete and insufficient. 3. The respondent did not appear to have reviewed the information and documents submitted to him by the appellant in response to his request, or if he reviewed the documents at all, he did not properly evaluate them and thereby grossly overstated the commissions attributed to the appellants for PS agents for the years 2019 and 2020. 4. The respondent did not provide the basis for the BOD assessment by showing or proving before us how it arrived at the BOD assessment, the factors it took into consideration, and how it ties the BOD assessment to the information and documents submitted to it by the appellant in response to his request during the tax investigation. 5. The respondent did not substantiate how it revised the 607 million naira, 772,500 initial BOD assessment down to 4 million, 862,914 naira, other than by its witness evidence, that it was after the many documents submitted by the appellant. However, it failed to show how the visual abuse of 42,535,417 naira per 7 added up before computing interest and penalty thereof. 6. The appellant filed its objection to the BOD assessment in less than 30 days after it was issued, and filed its appeal against the NORA within the 30-day period provided by law. 7. The respondent did not take into consideration the fact that the appellant objected to the BOD assessment within the time permitted by law before imposing interest and penalty thereof. Determination. Issue number 1. The jurisdictional issue by which the respondent challenged the decision of this tribunal on the note that the appeal is immature and not right for filing at the time that it was filed by the appellant. It is clear from the preponderance of evidence adduced by the appellant reports that the appellant objected to the respondent's demand notice within 30 days as required under Section 58, Subsection 1 of Personal Income Tax Act, and equally filed its notice of appeal dated 12 December 2023 within time as provided in Section 53 of the Ondo State Revenue Administration Government, which provides as follows. Quote, a taxable person agreed by an assessment income tax paid upon, having failed to agree with the service in the manner provided in section 3 of the Personal Income Tax Act, may appeal against the assessment upon giving notice as provided in section 24 of this law within 30 days after the date of services on the notice of the refusal of the service to amend the assessment. In filing this appeal. However, in the respondent's case is that the appellant should not have filed its appeal at all, despite the statutory time limit for this, because both parties were still exchanging correspondence. Then it meets the point, and this argument is not sound in law. This argument is similar to the respondent's argument in Windows Supply Trading Limited versus Federal Revenue Service 2011 for Tax Law Report of Nigeria, page 1. When the tax appeal tribunal TAT Lagos dismissed the respondent's preliminary objection to its jurisdiction on the ground that the appeal was filed when the appellant's notice of objection was still pending with it for review. In ruling against the respondent, the TAT Lagos held that NORA is not a precondition for filing a tax appeal, as a tax appeal is against an assessment, not the NORA, and an aggrieved taxpayer is at liberty to file a tax appeal against assessment, even when the NORA has not been issued. In this appeal, we hold that the exchange of correspondence between the parties after the NORA was issued cannot initiate this appeal. The appellant had a limited time to file its appeal and did not have the luxury of waiting until the respondent's final correspondence before filing its notice of appeal. Accordingly, this appeal is properly constituted before the Supreme Tribunal, and the respondent's objection to the tribunal's jurisdiction is hereby dismissed for lack of merit. Issue number 2: whether the appellant has discharged the onus of proof that the respondent's BOG assessment is excessive, arbitrary, unjustifiable, and inconsistent with the provisions of applicable laws are not to be set aside, as provided in sections 131 and 132 of the Evidence Act 2011 as amended. The burden of proof in this appeal lies on the appellant, being the party that asserts and who will fail if no evidence at all was given on either side. The Court of Appeal, by Honorable Justice Tom Shaibu Yakubu, JCA, gave expression to this in Mehaja Yedan 2017 LPLR 42474, where he said, quote, "It therefore logically follows that what is alleged without proof cannot be denied without proof. When the fact is asserted without proof, then the existence of the alleged fact is not established. Accordingly, we agree with the respondent that the appellant has the onus of proof that the guilty assessment is excessive, arbitrary, unjustifiable, and inconsistent with the provisions of applicable laws. Knowing that the merits of this appeal lies in its ability to discharge the bonus, the appellant did not deflect its responsibility for doing this. Rather, the appellant placed before us overwhelming evidence in his witness statement of oath, and the oral evidence of his witness which form the basis of his arguments in paragraph 2, subparagraph 1 to 11, under the parties' arguments above. In paragraph 49 of his final written address, the appellant's counsel argued that a tax assessment is arbitrary where there is no legal or evidentiary basis for imposing it. He defined arbitrary as an action which is based on chance rather than being planned or based on reason. He referred us to Federal Board of Inland Revenue versus JA of Montession 2012 Tax Law Report of Nigeria 89 at page 91 to 92, where MB Belgore J as a then was applied the principles laid down by the Privy Council in Income Tax Commissioner versus Badridas, the right shop accountant, 1937 LR 641 A 102. The tax authorities to follow when issuing the BOG. Quote, there remains for consideration the point whether the assessment can be attacked on the ground that it was not made by the officer to the best of his judgment. The officer has to make an assessment to the best of his judgment against the person who is in default as regards supply information. He must not act dishonestly or vindictively or capriciously, because he must exercise judgment in the matter. He must make what he honestly believes to be a fair estimate of the proper figure for assessment, and for this purpose, he must be able to take into consideration local knowledge and repute in regard to the assessing circumstances and his own knowledge of previous returns by an assessment of the assessee and all other matters which it takes to assist him in arriving at a fair and proper estimate of quote. This is another way of saying that before a tax authority, such as the respondent, issues a BOG assessment, it must be as scientific as possible by taking into consideration credible facts and figures which can be substantiated if challenged by taxpayers, such as the appellant to disappear. A BOG assessment is not a default assessment. The tax officials can resort to based on guesswork or phantom assumptions when they are not in a position to assess actual tax liability of the taxpayer. Rather, it's a fallback assessment that they have the power to issue under the law, using available information and reasonable estimation where a taxpayer has failed to file returns, or falsely correct or misleading returns, or keeps inadequate or no records at all, or refuses to cooperate with the tax authority. We do not underestimate the Herculean task that tax officials face in assessing a local taxpayer to tax in any of these circumstances. However, in this instance, the appellant gave copious evidence of the information and documents that is supplied to the respondent on request, as detailed in the above reference paragraph 2, 1 to 11, paragraph 2, subparagraph 1 to subparagraph 11 of the parties' arguments above. So considered view that if the respondent had properly reviewed the various estimates on their merits, it should not have used POJ assessments on the appellant at all. From all indications, the appellant was up to date in filing his utility tax returns with the respondent and kept proper records at the material point in time. It also cooperated with the respondent during the tax investigation by supplying the information and documents that the respondent requested for, contrary to the respondent's witness deposition and oral evidence. As explained by the appellant's witness during the hearing, the appellant supplied a list of 2,248 registered POS operators in the state in the Schedule 1 Exhibit UBA 5 to the respondent. Out of this, the appellant remitted the withholding tax deducted from the commissions paid to only 120 of the operators. It was on this basis that the respondent demanded the withholding tax due on the commission paid to the remaining 2,128 POS agents. However, the appellant's witness in his witness statement of oath and oral evidence during the hearing testified that the 120 operators from whose commission the withholding tax was deducted are remitted to the respondent, while the only ones operational at the relevant period out of the 2,248. He further testified that to the extent that the remaining 2,120 POS operators were not yet operational, and no commission was due or paid to them, there was no withholding tax due and payable to the respondent. Accordingly, the appellant's counsel argued that the respondent's POJ was excessive, arbitrary, unjustifiable, and inconsistent with the provisions of the applicable laws and ought to be set aside as it has no bearing on the document that the applicant provided to the respondent, which, if the respondent are properly evaluated on the merits, will have made it to agree with the applicant that it had no further critical ability, in addition to the amount already paid to the respondent. For the respondent to proceed to issue the POG assessment is against the weight of evidence in the form of documentary evidence submitted to it by the applicant in response to his request. I tell you again. For the respondent to proceed to issue the POG assessment is against the weight of evidence in the form of documents submitted to it by the applicant in response to its request. If the respondent were to be allowed to pursue this agenda without being checked by this honorable tribunal, the result will be that the applicant will be made to pay with liability in respect of transactions that did not exist. This is because the assigned POS agents to whom the POS assessment for the withholding tax allegedly related have neither commenced business nor had any commission on which the applicant would have deducted withholding tax for every tax to the respondent. Nothing could be more unjust and unfair to the applicant if the respondent were to have his way. From the facts before us, the respondent's witness statement of oath and oral evidence, there is no outside of evidence before us to justify the POG assessment, and we have no basis to resolve the issue in his favor as a failed to prove that the POG was appropriately issued. Accordingly, we resolve this issue in favor of the applicant and know that the applicant has discharged the onus of proof that the respondent's POG assessment is excessive, arbitrary, unjustifiable, and inconsistent with the provisions of applicable laws, and the POG assessment be and is hereby set aside. Issue number 3. Whether the applicant is liable to penalty and interest having objected to the assessment within the time limited by law. To the extent that penalty and interest do not exist in power, whether a function of non-payment or late payment of taxes, and we have set the POG aside, POG assessment aside in this appeal, we can actually conclude that this issue has become a non-issue and unworthy of any further consideration. Nonetheless, for the sake of any appeal that we see from this gentleman, the word that the applicant is not liable to penalty and interest because it's objected within time, but it's been to alleviated to the respondent's demand notice and NORA respectively, and file this appeal within 30 days from the date it received the respondent's NORA. In making this decision, we are persuaded by the judgment of the TAT Lagos Zone, the Weatherford Services SDRL versus FRS 2016 26 Tax Law Reports of Nigeria 344, that interest and penalties on tax assessment do not begin to accrue where the taxpayer has validly objected or appealed within the statutory period. Further to this, we hold that interest and penalty only arise where the taxpayer fails to object to the dated assessment or fails to appeal to the TAT within the statutory allow for objection or appeal. Where a taxpayer files a valid objection to appeal in time, the assessment is not final and conclusive, and no interest or penalty they are put there during the period. Conclusion. To resolve all the 3 issues of determination in this appeal in favor of the appellant, accordingly, this appeal succeeds on all the grounds, further to which we grant the following orders in favor of the appellant. Another setting aside the respondent's demand notice dated 24th August 2023 for 54,862,000 for POG assessment, and NORA dated 7th November 2023 for being arbitrary, excessive, unjustifiable, and inconsistent with the provisions of the applicable law. 2. Another discharging the appellant from any liability whatsoever for the said POG assessment and portion the dated demand notice dated 24th August 2023 in respect of the years 2019 to 2020. Lastly, which is the third order, Another dismissing the respondent's counterclaim for that offense relies on the following orders. This is the unanimous judgment of this tribunal, and we so decide.
The tribunal citizens. Honorable Tribunal, we thank the tribunal for the well thought out.
Can't see above your neck. Show your face.
We thank this tribunal for the well thought out judgments and for the industry as electing fair hearing, polite hearing between the parties throughout the hearing.
Or you're barely. Thanks so much. Yeah, for the purpose of the verbatim recording machine, can you repeat yourself so that it can be properly heard? You need to unmute yourself.
Honorable Chairman, I don't know if you can hear me.
Yes.
Okay. So we thank the Honorable Tribunal for the well thought. Chairman, did you say something?
Go ahead.
We thank the tribunal for the well thought out judgments for the industry and letting the parties have fair hearing throughout the process. We are very, very grateful for the judgments.
Online from the respondent who wants to speak. I can take down your appearance at this time. No one. Okay, all right. The judgment will be ready by the end of business today. If any of you wants to collect the certified true copy for the purpose of appealing the judgment, we are liberty to do so. So please contact the registrar and the certified copy will be given. The certified true copy will be available to you accordingly. Thank you. Now we'll take a short break and we'll be back within the next 15 minutes to carry on with the proceedings for today. Right. Awesome. Perfect.
Hello, Mr. Tolu. The virtual hearing has ended, I presume. I can't hear you if you're speaking. You're muted.
Yes, sir.
The virtual hearing is done, right?
Yes, sir.
No, it's not done. They only take a break.
No,
The other case still a virtual hearing. This is the only one that is a virtual hearing, right?
This is the only one, sir.
So the other ones will continue the way they normally continue. It doesn't need to be a virtual hearing now, correct?
Yes, sir.
So I'll end the virtual hearing link now.
All right. Yes, sir.
All right, thank you. Thank you very much.
What about allowances? Allowances for
Ask your CS. Send a memo to your CS.